This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why the insurer USAA was punished for its claims handling after a hurricane, and why punitive damages should be awarded with caution and within narrow limits. But in this case, a dispute over hurricane damages resulted in major punitive damages for the alleged tort of bad faith. Although the Mississippi Supreme Court recognized the need to only award punitive damages with caution and within narrow limits, it did not limit its award in accordance with that maxim. After almost 19 years of litigation, the last appeal resolved the various disputes. Hurricane Katrina, many years ago, in 2005, destroyed Paul and Sylvia Minor's home. The Minors had a homeowner's insurance policy with the United Services Automobile Association, USAA. The USAA policy covered damage caused by wind, but excluded damage caused by storm, surge, or flood. The Minors reported their loss with USAA, which resulted in a years-long coverage dispute. USAA ultimately issued payments for damage it concluded was caused by wind, but not for damage it concluded was caused by storm damage, storm surge, or flood. The Minors maintained they suffered a total loss caused by wind and demanded that USAA pay the policy limits. The case proceeded to trial in 2013, and the jury awarded the Minors $1,547,293.37 in compensatory damages. In USAA versus the estate of Sylvia F. Minor, Catherine Minor, and Stephen Minor, the Supreme Court of Mississippi en banc on December 5, 2024, resolved the bad faith claims. The issue was ultimately presented to a jury. The jury awarded the Minors $10 million in punitive damages and $457,858.89 in extra contractual damages, solely attorney's fees. USAA appealed, raising several assignments of error. After several appeals, there was a second trial, and to establish its bad faith claim, the Minor estate introduced various USAA documents, including portions of the USAA underwriting file, the confidential email regarding the engineer's March 2006 findings, Bergstrom's conclusion that USAA would be responsible for paying for all the windows and the contents in rooms with windows, and 3, USAA's letter to the Minors in June 2006 indicating the majority of damage was due to flooding. Punitive damages in Mississippi are considered an extraordinary remedy and should be awarded with caution and within narrow limits. The Supreme Court found that the evidence presented at trial demonstrated a type of conduct for which punitive damages were designed. The Minor estate provided sufficient proof to the Supreme Court of Mississippi that USAA acted in bad faith with complete disregard for the estate's rights. USAA argued that the $10 million verdict should be reduced because it claims that the damages award is 22-to-1 ratio and therefore unconstitutionally disproportionate to the extra contractual damages of $457,858. USAA relied on State Farm Mutual versus Campbell, a U.S. Supreme Court decision from 2003, which states that a single-digit multiplier are more likely to comport with due process. USAA argued that a 1-to-1 ratio should apply to the damages awarded. In this case, the Supreme Court, however, found that the punitive damages was less than 7 times the amount of compensatory damages, which it concluded clearly falls within the guidelines provided in State Farm versus Campbell. A punitive damages award, according to the Supreme Court, not only serves as a deterrent, it also compensates the plaintiff for its public service in bringing the action. The Supreme Court found that the trial court's decision to force the minor estate to use nearly half its award to pay attorney's fees does not adequately compensate the estate for bringing the action against USAA for its bad faith conduct in handling the minor's insurance claim from 2005. Therefore, the Supreme Court concluded the trial court erred by delaying and denying the estate's post-trial motion for attorney's fees. In sum, the Supreme Court concluded that the trial judge did not err as a matter of law by submitting the issue of punitive damages to the jury, and the $10 million award of punitive damages is not unconstitutionally disproportionate. The Supreme Court affirmed the jury verdict awarding the minor estate $10 million in punitive damages and $457,858 in extra contractual damages as to attorney's fees, and reversed the judgment of the trial court and render attorney's fees on behalf of the estate in the amount of $4,500,000, plus post-judgment interest at an annual rate of 4% from October 3, 2022, the date of the judgment, until paid. This case that dragged on through the courts of Mississippi for 19 years and resulted in compensatory damages based on an interpretation finding coverage for the estate, and that the insurer's conduct was so egregious by applying exclusions that the estate was entitled to tort damages plus punitive damages many times more than the compensatory damages. The Supreme Court astonishingly concluded that punitive damages were not limited to punishing the insurer, but were payment to the estate for its action on behalf of everyone in the state of Mississippi, and that they should not be required to pay their lawyers, but that payment should come from the insurer as part of its punishment. The Supreme Court ignored the fact that as a result, the estate must pay income taxes on the punishment damages, since they are not designed to make the insured whole, and punished each member and insured of USAA. In my opinion, it's time the courts of the USA do away with the tort of bad faith to avoid excessive judgments and allow contract disputes to be enlarged into a major amount of punishment for an insurer who rejected a claim based on interpretation of contract terms and the facts of a loss which the Supreme Court of Mississippi found to be incorrect. In that regard, please see my book, quote, "It's Time to Abolish the Tort of Bad Faith," close quote, which is available as a paperback and a Kindle book from Amazon.com. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,950 blog postings. You can also subscribe to these videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.